Welcome back to Court Watch, where real cases unfold in real time. Today we've got a heated courtroom battle in the state of Texas versus Shalis Schnitz. This case isn't just about legal motions. It's about custody battles, allegations of abuse, and the dangerous consequences of YouTube broadcasts entering the courtroom. Stick around, because the drama you're about to see will leave you questioning how far the law should bend to balance justice, safety, and privacy. Let's get right into it.
Right, and any file that I don't currently have now, you are going to have to come back on a different day. So I have Kevin Owens, Ernest Morales, Uriah Huffman, and Norma. They'll have to come back in the afternoon. Those are the cases that I have. Court is calling 2023 CR 5651, State of Texas versus Shalis Schnitz. Am I pronouncing your last name correctly? All right. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Shannon Locke for Shalis Schnitz.
And?
It's Mr. Javier Garcia.
All right. Is he on the case as well?
Yes.
All right. You want to announce for the record?
Javier Garcia, Your Honor.
All right. So I have several motions before me. The first is the motion for defense to conduct an independent analysis of the defendant's blood sample. Did you all review that?
So we took a look. My understanding of that motion is that defense wants to get the second vial of blood taken by BCSO in this case and send it through their own lab. I mean, the state has no objection. I think that's something that they have the right to do.
Okay. All right, that will be granted. And of course, the laboratory here will have to make safeguards, and that's not in the court's purview to make safeguards for the analysis.
Right, Judge. My understanding is that the defense will have to, whoever is analyzing the blood for them will have to pick up the blood from BCSO, and there will have to be a clear chain of custody. So that's something that they're going to have to do.
That's correct, Your Honor.
That the safeguards are in place.
Here's where things get interesting. The defense just won the right to test a second vial of the defendant's blood with their own independent lab. Why does this matter? Because independent testing can sometimes reveal discrepancies in state labs, and that can be a game changer. But with chain of custody rules in place, the defense has to carefully track that blood sample, or risk losing its credibility in court. What do you think? Should defendants always have the right to double-check the state's evidence?
Quiet, please, in the courtroom.
All right, everyone, you need to whisper. All right, and then the motion to inspect, examine, and test physical evidence.
My understanding, Judge, is that the defense wanted in that motion to take a look and inspect the vehicles that were involved in this case. My understanding is that they are in the Bexar County. They're in Bexar County's possession, so that's something that we can try and facilitate. It's just coordinating everything with everyone. I know that the detective in order for us to inspect, he has to be there.
All right, so do y'all still want to keep number one where it says that you are to produce the vehicles? Because I don't know if that's the proper wording.
Just make available to us for inspection, Your Honor.
All right, if y'all want to put in there to make available for inspection instead of produce.
This initial, Your Honor, that's
Yes.
Mr. Escobar's handwriting.
Initial few, Judge. Here you go.
All right, thank you.
Notice how the defense is pushing to inspect the vehicles tied to this case. This isn't just busy work. Vehicle inspections can reveal hidden evidence like damage patterns, fluid samples, or even overlooked trace evidence. But the real drama? The judge is carefully rewording the motion from produce to make available. That might sound minor, but in legal terms, it shifts responsibility and avoids forcing law enforcement's hand too far. These small details often decide how much access the defense truly gets.
All right, that will be granted. And then there's a request for no broadcasting. Is that correct?
That is correct.
All right. So the court has read the defense's motion, and what I can tell the defense is, number one, the court limits the number of people in the courtroom for security reasons, also for health reasons. I think everybody is aware of the brawl for want of a better word, brawl, skirmish, or whatever that occurred in the other courtroom. As everybody is aware, there are only a limited number of deputies. I have 2 deputies in this courtroom, and we almost had another incident here today that I think would have turned quite differently if the courtroom were packed. The court must have an open courtroom to the public, and that is how the courtroom is keeping it open to the public. So I've read your motion, and that motion is denied.
And here's the bombshell. The defense is asking to block all broadcasting. Why? Because Schnitz claims YouTube videos of her trial are being weaponized against her in a child custody battle. Think about that. Her ex allegedly monitors these streams, records them, and spreads the details online. Suddenly, this isn't just about criminal charges. It's about how the digital age collides with courtroom privacy. Should open courts mean open broadcasts, even at the expense of personal safety?
Your Honor, may I make a little bit of a record on that?
Sure.
Okay. And so Ms. Schnitz has some specific things that have affected her as a result of the broadcast over YouTube. And specifically, Your Honor, the open courts, one, we don't think that you need to close the courtroom to non-participants. So we object to the closing of the courtroom, which we were just made aware of this morning. So we have that objection. We think the courtroom should be open to live audience members. Ms. Schnitz is in a very particular situation. She's in a custody battle at the time, currently, and her ex-husband monitors these YouTube videos. He saves them and broadcasts her information to her friends and family and uses it in her child custody case. Additionally, Your Honor, so I'm going to have Ms. Schnitz speak to that if she could.
Sure. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Shalis Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
oh, the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very, very serious situation. And he is using the YouTube videos, and he's explained that in emails to watch what is happening on court to find the location of my daughter. And I'm sorry.
This moment is chilling. Shalis Schnitz just revealed that her ex-husband, who is under investigation for sexual assault, has been using court live streams to track her and her daughter's location. Imagine the fear, trying to fight criminal charges while knowing your abuser is watching every move through YouTube. The legal system is built on transparency, but this testimony highlights the dangerous cost of letting personal details leak into the public sphere. If you were the judge, would you allow the broadcast to continue?
Shalis Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
oh, the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very,
Did you catch that? Schnitz says she feels forced to choose between entering a guilty plea or being publicly exposed on YouTube. That's a staggering claim. A guilty plea means losing in court, but live streaming means risking her child's safety. This is where the courtroom transforms into an ethical battlefield. The law demands openness, but the individual begs for protection. The stakes couldn't be higher.
No, that's all right. I have no further
Any
questions.
questions?
Nothing to say, Judge.
All right, and the court will state again, everyone is aware of the brawl, skirmish, whatever you want to call it, that took place in this courthouse recently. No less than, I think, 10 deputies or maybe more were summoned. There was a fight in the jury box where audience members came from the audience and attacked someone, and I will use the word allegedly, but I think everybody is aware of it. An inmate that was in the box. We just had what could have been a bad incident in this court today, where deputies had to step in and escort somebody out of this courtroom. This is a court that needs to be open to the public. I am not going to allow people in the courtroom for safety reasons. I'm not allowing people in the courtroom unless they are a defendant, a person accused, or unless they are a witness. And those witnesses will be brought in when they are needed. The state will tell you, and other persons in this courtroom will tell you, anyone who is given victim impact, they can come in when it's time for them to give victim impact. But that is the way this courtroom will be run. So for security issues, we only have 2 deputies in a courtroom, and we have a third, sort of a third. And I say third because he's wearing his jacket, right? But he's not assigned to this courtroom. So when you think about it, right now we have 1, 2, 3, 4, 5 people in the box, and really normally only 2 deputies. And sometimes we have 10 people in the box. So the motion is denied, and we're going to come back
Your Honor,
on December 12th.
And the judge delivers his ruling, motion denied. He cites security concerns, past courtroom brawls, and the necessity of maintaining open courtrooms. To him, safety trumps privacy. But notice his stance. Live streaming will continue despite the defendant's fears. This is the heart of the debate. Should the justice system evolve to protect individuals from digital exploitation, or is open access too important to restrict? Let us know in the comments where you stand.
just one other question. Could you admonish people not to record the broadcast?
Oh, people, I am not in charge of broadcasting.
But so what happens is people will capture, like they'll capture this event, they'll put it on other platforms.
And what I can tell you, counsel, is in this courtroom with your client, I have never asked, nobody's ever asked. If I'm wrong, tell me I'm wrong. Nobody's ever asked what school her child is at or asked any of that nature. With regards to a civil case, that's something that needs to be addressed civilly. This is a criminal court.
But what happens, Your Honor, and the problem is that this is now, the YouTube broadcast is as much an official record as the court reporter's.
No, it's not. The court reporter's record is the official record. I made my ruling. You all are coming back on December 12th. On December 12th, I expect everyone to have their discovery in order. If there's more time that's needed to look at a vehicle, let the court know. If there's some issues with the blood, let the court know before the December 12th setting. All right, Ernest Morales.
Thank you, Your Honor. May we be excused?
Yes, you may be excused after you sign the reset form.
Thank you very much.
So here's the takeaway. The defense secured rights to inspect blood in vehicles, but failed to stop public broadcasting. For Shalis Schnitz, that means her case and her personal struggles remain exposed online. This case highlights a modern dilemma. When the courtroom goes digital, privacy, safety, and justice collide in ways the law is still catching up to. What do you think? Should live streaming court cases continue, or do risks like this outweigh transparency? If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.